Let's go ahead and get started if we could. Tracy Equazi, did I get that anywhere near? No? There you are. Can you help us with Rosenbaum versus First American National Bank when we get to it? No? Say again? What? Is it just that case or what? What? Okay. Austin Mitchell. How about Rosenbaum versus First American National Bank? Rob Collins. Wharton versus Bridges. Jamie Casey. Miss Casey. Burvotes versus Hardy Rawls. One more. Joe Hall. Mr. Hall. Vols versus Leeds. Just a heads up about one of the cases that is on the list for next week. Sterling versus Vesical Chemical Corporation is an opinion that's 235 pages long. That's the bad news. The good news is we're only going to cover the first 16 pages in the reporter version. So there's no need to print out that whole thing, and unless you just want to and read the entire opinion. But the rest of us are only going to talk about the first 16 pages. So that note is indicated on the list on your syllabus, but I just wanted to bring that to your attention so you didn't inadvertently just hit print and the whole thing come out. I had an interesting experience earlier this week that I'll pass on to you for whatever it might be worth. But as part of my job, to me, this isn't a job. This is fun. I enjoy this. This has never felt like a job. But in my job, one of the things that I get to do that I do enjoy is to help train our state's judges on all courts, from the lowest court to the highest court. And so I do a lot of teaching and speaking at judicial conferences all across the state. So on Monday, I spoke to the state's juvenile court judges conference, and they're from all over the state. We have lots and lots of juvenile court judges in Tennessee. And so after I did my thing, a former student who's a judge came up and he said, "I had you in 1992. Which immediately took me back to when I was like 24 or 25. And he said, when did you retire? And I said, well, I haven't. And he said, oh, okay. And then, we chatted for just a minute. And then another former student came up who is a judge. And this one said, I forget the exact year, but I think it was like 2000. And she said, are you still? I said, yes, I'm still. And in fact, I had class that night. So Monday night, I teach it towards 2. So I told her, yeah, I'm still there. I got class tonight. She said, well, that's really cool. Good seeing you. We chatted a minute. To make a long story short, 9 other former NSL people came up, and it was great. One of them was so excited that she said, can I take a selfie? And so we did that. And then she said this, and this is what I want to pass on to you all. She said, going to law school was the hardest thing I ever did in my life. She said there were some classes where I just did not do well at all. And there were other classes that I did pretty well. And she said there were times when I had no idea how I was going to get through even the next week, because I reached a point where I was, what word did she use? Depleted. Physically, mentally, she just was depleted. But she never gave up. And each of those judges expressed some version of, had it not been for NSL, they would not have the really cool career that they have as family and juvenile court judges, impacting in profound ways kids and families every single day they go to work. And it's just interesting to me, having had a very small part in their legal education. And I run into judges all the time, from one end of the state to the other, who are NSL people. But it's very cool for me to just see how those circles come all the way back around, even after 20, 30 years. And seeing how people that sat right where you sit are now in a position of adjudicating and deciding issues involving kids and families every single day. And but for this school, they would have never had that opportunity. And but for that one particular judge who said that she had reached a point where she was just depleted, but for her continued, her determination to just keep going, just 1 week at a time, just keep going, she wouldn't be where she's at today. So I just thought I'd pass it on to you for whatever that might be worth. Oh, there was another one. This one really did make me feel old as dirt. We chatted for a minute, and as he was walking away, he said, oh, I meant to, one other thing I was going to tell you. He said, next year, you're going to have my daughter in class. Wow. So I thought, oh my goodness, I'm going to have the students of the children of former students. So, but I'm not, decrepit just yet. I'm not depleted. I still have a ways to go. To me, this is not work. This is fun. I don't know that you would quite characterize it as fun. You probably would characterize it as work. And I get that. It's very hard. You're doing something hard. This ain't easy. If it were easy, everybody would do it. All right, so tonight we are going to talk about some multiple defendant issues, and there are several issues that do come up when there is more than one tortfeasor involved in a case, or when the circumstances are such that a party is legally responsible for the harm, but they didn't do anything wrong. They weren't negligent. They're responsible because of what somebody else did. Like an employer liable for the negligence of an employee. So when you have a situation like that, or you have a situation where there are multiple defendants in the case, there are certain issues that the courts have and the parties just have to figure out. You know, if you have one plaintiff against one defendant, those are easy cases logistically and administratively to shepherd through the judicial process. But when you start adding parties, either multiple plaintiffs, multiple defendants, or both, then things can become pretty unwieldy. So with that in mind, let's begin to think about some of the issues that arise when there are multiple defendants in a case. The first of these issues, and they're in no particular order here, but the first one has to do with allocating damages among those multiple defendants. And there are several concepts pertinent to this topic. The first being what is called a satisfaction. A satisfaction in this context is defined as full acceptance by the plaintiff. Full acceptance of compensation for the harm at issue. It's full acceptance of the compensation for the bad thing that happened to the plaintiff. So here's the significance of a satisfaction. That means once the plaintiff is satisfied, once the plaintiff has been made whole, either through the payment of a judgment or through a settlement, but the plaintiff has been satisfied, the significance of that is that the plaintiff cannot recover against other tortfeasors for the same harm. The plaintiff can't, once he's satisfied, can't decide, oh, well, that's just not enough. I'm going to sue again. I didn't recover against B. I did recover against A, but I never sued B, so I think I'm going to go back into the court system and try to recover damages from B. You can't do that. Once the plaintiff has been satisfied, he's done. He's out of the case. He can no longer proceed against other liable parties. So let's say, just to make this a little more concrete, what if the plaintiff, what if a truck driver for Walmart is negligent, causes an accident, and the plaintiff sues the employee, sues the negligent driver, but also sues Walmart on the basis of respondeat superior. And the jury awards whatever amount of money, $50,000 in damages. Let's assume that Walmart writes the plaintiff a check for $50,000. Query, can the plaintiff recover the $50,000 that was awarded against the driver of the truck? The answer is no. Plaintiff has been made whole. He's been satisfied, and the significance of that means that the plaintiff can no longer churn the proceedings in an effort to get more money. And he's out of the case. And that's going to set up what we're going to talk about here in just a few minutes. Once the plaintiff's been made whole, he no longer has an interest in how the defendants allocate damages among themselves. But hold that thought. You should also know that in the world of tort law, there is something called a release. A release basically is a settlement agreement, or at least a part of a larger settlement agreement, whereby the plaintiff surrenders his claim, surrenders his tort cause of action, whatever that might be, against the party to whom that release is given. So the plaintiff provides this release. What then does the person to whom the release is given provide? Money. It's a settlement agreement. Plaintiff says, I'll surrender my claim, my cause of action, in exchange for a certain sum of money, and that is called a release. Here's the significance of that. A release given to one tortfeasor discharges from liability only that tortfeasor and nobody else, unless some other, unless contrary language is stated in the release. Or maybe to explain it a little bit differently, the rule used to be that if a plaintiff gave a release to one person, it had the legal effect of releasing everybody else on the planet. So a release given to one released everybody. That used to be the predominant rule. It is not the predominant rule today. In most jurisdictions, a release of one tortfeasor only releases that tortfeasor. So let's say that A, plaintiff, A sues B and C. A and B settle via a release. Query, does that have any effect on C? It does not. It used to. It would mean that C got a free pass and was able to avoid liability, but that is not the rule today, and it's not the rule in Tennessee. And then there is something called, as we're just working through some basic terminology here, there's something called a covenant not to sue. When you hear the word covenant, what do you automatically think of? Okay. What else do you automatically think of? Yes. Okay. Yes. Or even reduced more simply, a covenant is just it's a promise, right? It's a promise. a covenant not to sue, a promise not to sue. So a covenant not to sue is the same thing as a release, except that it doesn't extinguish the underlying tort claim like a release does. Remember, with the release, the plaintiff is giving up that claim. It's no longer there. It evaporates in exchange for money. But with a covenant not to sue, the parties have just entered into a contract where the claim is still there. It's just that the plaintiff has agreed not to enforce it, usually in exchange for money. So that's the technical distinction between a release and a covenant not to sue. Now, like a release, a covenant not to sue doesn't discharge other defendants or potential defendants from liability. So in that respect, a release and a covenant not to sue work alike. Either one given to one party only affects that party. That said, there is a big exception. The exception applies when liability is vicarious. And in that instance, a release or covenant given to the agent has the effect of releasing the principal. So like in a respondeat superior situation, a release given to the employee would have the effect of releasing the employer. That's the big exception. If liability is vicarious, a release or a covenant given to the agent has the legal effect of releasing the principal. And that's a big deal. Let's look at a case that involves some of these concepts. Rosenbaum versus First American National Bank. Mr. Mitchell, tell us about this one.
Okay, so the jury directed a verdict for the plaintiff, awarding him $75,000 and then $15,000 for his wife against the defendant, and then the defendant's motion to have those damages or not damages, but the awarded money from Murray and ESA to be accredited, and then the plaintiff appealed.
What happened? What's this case about? What are the facts?
The bank had a drive-through for nightly deposits on the back of the bank, and ESA was the architect and creator of that design. Murray was in charge of the security at the bank, and on August 5th, the plaintiff...
Who hired Murray Guard Company?
Sorry?
Who hired Murray Guard Company?
First American National Bank.
The bank. Okay, what happens next?
On August 5th, the plaintiff was shot and robbed while he was making a nightly deposit.
All right, who gets sued?
First American, all three of them did.
Three?
Or First American National Bank did.
So the bank gets sued. Who else gets sued?
Murray did, and then ESA did.
Guard Company, that's two.
And then the architect.
The architect gets sued. ESA, one more.
Is it the mall, the shopping center? I'm not sure.
got 100 embryonic collie
Kevin
lawyers
Tucker
here to help
Associates.
you out.
Kevin Tucker Associates.
Kevin Tucker and Associates.
And who's that?
I believe that it was with the architect, like the firm with the architect. The landscaping company? The landscaping company.
Okay, so the landscaper got sued. The architect that designed the drive-through area gets sued. The guard company gets sued, and the bank gets sued. Multiple defendants in this case. According to the plaintiffs, what did the bank do that was negligent? What did the bank do wrong?
They failed to take remedial action to protect their customers.
All right, they failed to take reasonable steps to protect their customers. Does that sound familiar? You remember the Walmart case we read some time ago? Plaintiff was making the same argument. Walmart failed to take reasonable steps to protect customers in its parking lot. Plaintiff here makes the same argument. Plaintiff also argues that the bank negligently hired and supervised the guard company. Remember when we talked about employers and independent contractors? We discussed how even though an employer of an independent contractor is normally not vicariously liable, the employer can be held directly liable if the employer in its own right is negligent. And that is what the plaintiff is saying here. Plaintiff is saying, bank, you negligently, you failed to exercise reasonable care in hiring this company because they're clearly incompetent, the argument goes. And you failed to supervise them. So bank, you're liable. According to the plaintiffs, what did the guard company do wrong?
Failed to train their officers.
Failed to train their employees, failed to supervise their employees. Plaintiff says the guards were just sort of goofing off, not really paying much attention, sitting on cars, listening to the radio, watching TV, instead of guarding the bank's premises. And then the plaintiffs argue, oh, yes, and the architect was negligent in how it was all designed, and even the landscaper was negligent in putting the bushes where he put the bushes. As this case gets close to trial, what happens to Tucker, the landscape company? What do the plaintiffs decide to do to that defendant?
They non-suited them.
They non-suited them. What does that mean?
They took them out of their complaint.
Well, essentially, yes. A non-suit just means you let that defendant go. You just turn that one loose. And there's no release, and there's no covenant not to sue. There is no settlement. No money changes hands. You just decide, for whatever reason, to just eliminate that defendant from your case. Here's my question. Why would you do that? That's not in the opinion anywhere, but why would you, as you're getting close to trial, why might you non-suit somebody? Especially if they aren't going to pay you any money.
Were they not negligent enough?
Well, I don't know, but why might, if you're a lawyer and you have your plaintiff's counsel and you sued multiple defendants, and you're getting real close to trying the case, why might you just let somebody just non-sue, let them go?
If the case is weak against one of the defendants, but really strong against some of the other defendants, you might just eliminate that one defendant from the case, because you don't have that strong of a case against them, just leave it up with us.
The more defendants you have, the more unyielding that case becomes, especially for jurors. And so as you get closer to trial, you want to begin to pinpoint your efforts and your arguments and your energy so that you can make it as easy for the jury to decide the case in your favor as possible. And so if you need to eliminate some of these multiple defendants, well, you're not really sure now that you've fully developed the case, you've done the discovery, taken the depositions, you've thought through the issues. Maybe you decide for strategic reasons, I think I'm just going to throw that one back in the water. Just take them off the hook, just let them go. That's called a non-suit. All right, so the landscaper is out of the case. Now the parties are just about a week out from trial. What happens procedurally? What's the next big thing that happens to this case?
Murray and ESA, they settled.
For how much?
Murray settled for $20,000 and ESA for $4,000.
Okay, so 2 of the remaining 3 defendants settled. Total of $24,000 in exchange for a release. So when it comes time to actually try the case, the only defendant in the courtroom is the bank. What happens at trial?
The jury awarded the $75,000 verdict for the plaintiff and then $15,000 for the plaintiff's wife.
Why would the wife wasn't shot? Why would she be awarded $15,000? You won't find that in the opinion. But if you think back to the very beginning of the year, why would the wife be awarded $15,000?
Third party IAD.
No?
Steve.
Loss of consortium?
Loss of consortium. And it wouldn't make any difference whether she was there at the scene or not, right? Remember, loss of consortium is that bundle of tangible and intangible benefits associated with being part of a family. And when one person in that family is tortiously injured, and that has an impact on a spouse, that spouse has this claim called loss of consortium. And that's what you see here. Okay, so the bank is held liable to trial. Jury says, yep, bank, you're negligent. And we award $90,000 in damages. Then what happens?
The bank amended their judgment and or motioned to amend their judgment, and the trial court allowed for it, and they credited the original judgment.
What authority is there to do that?
The release.
legal authority is there to credit a judgment for an amount that the plaintiff settled for?
I'm not sure.
Well, we have a statute in Tennessee, and the court sets out the language, 29-11-105. And the statute says in pertinent part, when a release or covenant not to sue is given in good faith to one or of two or more persons liable in tort for the same injury, number one, it does not discharge any of the other tortfeasors from liability. You remember I said a few minutes ago that the rule used to be that a release or covenant given to one releases everybody? That language in paragraph 1 is the statutory change in the common law. So Tennessee is one of those jurisdictions by statute. It says you give a release or covenant to one tortfeasor, it only affects that tortfeasor. Well, but paragraph 1 also goes on to say, but it reduces the claim against the others to the extent of any amount in the release or the covenant. So under this statute, a non-settling defendant would be entitled to a credit for the amount or amounts that the plaintiff received from other tortfeasors. Paragraph 2 of the statute says, it discharges the tortfeasor to whom it is given from liability for contribution. We're going to talk about contribution here in a bit. And 2B says, no evidence of a release or covenant not to sue may be introduced at trial, but may be introduced upon motion after judgment to reduce the judgment by the amount stipulated by the release or the covenant. And that is exactly what the bank did here. So the trial takes place, it's over, jurors go home, and then we begin what I call the mop-up. The bank files a motion with the court saying, hey, based on this statute, the $90,000 judgment against me should be reduced by the $24,000 that the plaintiff settled for. The trial judge says, you know, you're right. Judgment reduced accordingly. Plaintiffs appeal to the Court of Appeals. And obviously the plaintiffs don't want their $90,000 judgment reduced. So what argument do they make to get around this statutory language that is pretty clear? How do the plaintiffs try to convince the Court of Appeals that the trial judge erred in reducing that judgment?
They said it was inapplicable.
Say again?
They said that the statute was inapplicable.
Why or how?
Anybody?
Was it that they were essentially arguing that, in the case, they said that the different tortfeasors that they had cited in the original suit weren't actually tortfeasors at all, they didn't have duties. So they couldn't say that they had a duty when initially they argued that they didn't. So they're not tortfeasors, so that shouldn't be deducted.
I think that's the gist of it. My paraphrase of their argument is, had these defendants not settled and remained in the case, they would not have been found liable. That's one way to put their argument. Maybe another way to put their argument. Yes, Your Honors, I know we sued them and we said they were negligent and did all these bad things, but really they didn't. I know we said that on the front end and we took them all the way through this arduous litigation process, but we'd have lost. They wouldn't have been found liable. They really didn't do anything wrong. What was the Court of Appeals' response to that? Does that judgment ultimately get reduced? Does the Court of Appeals agree with what the trial judge did or no?
He agreed, or they agreed.
Yes. Now, the harder question is always why? What's the rationale for the decision? How'd the court get there?
Because when ESA and Murray settled for the release, it got rid of the right to be pursued as defendants.
Not really. Think very practical.
The court encourages settlements.
The statute is designed to encourage settlements. And if the court were to adopt the plaintiff's argument and make it part of the common law, the court says, we would have to have the main trial, and then we would have to have all these collateral mini trials to figure out whether the settling tortfeasors would have been held liable had they not settled. Well, you can imagine a court reacting strongly to any such notion. I mean, you talk about a process that is inconsistent with judicial economy and efficiency. We gotta have the main trial, and then we just spiral off and on other dates in front of other juries do the same dance with all these parties that might have settled to try to figure out whether they were negligent or not. When you, plaintiff, said on the beginning they were, and now when it's no longer convenient for you to make that argument, you throw up your hands and you say, they really didn't do anything wrong. I'm not a bit surprised that the Court of Appeals was not persuaded by that argument. So the court says there is a test. I use the word test. There is a test to determine whether this statutory settlement credit is to be applied. What is that test?
Whether the defendant was sued as a tortfeasor.
That's it. Did you sue him? That's it. Did you sue him? Yes. Okay. Then they're entitled to the credit. And the statute works. You trigger the statute. You sue them, that's it. We're not going to get into this mini trial business. What's this case teach you about the law? Before you read it and after you read it. Now what do you know about the law that you didn't know prior to?
If you don't have a strong enough case against multiple defendants, pick the ones that you do have a strong enough case with and go after those.
Well, okay. That's certainly a good litigation strategy. Go with your strongest argument against, take the strongest position that you have and run with that. You go into trial with a bunch of defendants and just throw up against the wall just to see what might stick, you might be sorely disappointed that nothing sticked. Or stuck. Yeah. Nothing stuck. Nothing stick. Yeah. What you see played out here is really quite common. Because on the front end of the case, you haven't done discovery yet. You haven't taken any depositions. All you really know is just what the story your clients told you. And maybe you've done some, and should have done some investigation so that you have a good faith basis to sue. You don't have a good faith basis to sue. That's an ethics problem. And the Board of Professional Responsibility can ding you for that professionally. So you do have to have at least some good faith basis in law and fact to sue anybody for anything. But remember, on the front end of the case, you haven't fully worked it up. And so as you go through the litigation process and you become much more in tune to the nuances of the case and who did what and when and why, that's when you're in a position to make informed decisions about who to keep and who to let go. That you winnow things down to make it as easy for that jury to decide it in your favor as you possibly can.
I have a question about comparative fault. So in a case like this, where there's multiple defendants, and say 3 of them settle, and only 1 defendant goes, and then the jury allocates fault by percentage, but it allocates more fault to the defendants that have already settled than what they paid, then how does that work out?
We're headed in that direction. We're headed there. So hold that thought. We're moving toward that. Just hang on to that. That's a great question. We're headed there, headed that way. Thank you, sir. Yeah, you had a,
Just a quick question. Am I incorrect in making the inference then that if you try to you were trying to settle with a potential tortfeasor before you sued them and you settled with them, that maybe it was like a slam dunk, type thing, that would that still offset any other?
start that over. Start that over.
Okay. Suppose you had 3 potential defendants. And let's say, there was one that, was kind of a no-brainer and you filed suit against that tortfeasor. Hadn't joined the others, right? But perhaps you went over to one of the non-suited, one of the folks that are not party to the case yet, and said, hey, this is going to look bad for you. Can we settle down before I join you to the case? If they actually took a bite on that settlement, would that settlement, since they weren't joined to the case yet, offset any judgment against first one or the subsequent tortfeasors that's going to the case?
What was the test?
If you file a suit.
Did you?
Sue
Okay.
against them.
Did you file a suit
File a suit, yes.
against that defendant?
No.
Okay, then you did not meet the test.
That's what I wanted to clarify.
Yeah. The court says, here's the test. So your hypothetical didn't meet the test. Notice something very important here. Rosenbaum predates McIntyre versus Valentine by a few years. So the question after comparative fault would be, should there be an instance like Rosenbaum where that settlement credit would be applied? That's your question. What do you think? If Rosenbaum were to take place today, how should things shake out? Yes, ma'am.
I would think that there would not be a need for credit because you already apportioned that once they settled, they were removed from the case, I would presume. And so now the fault is between the two parties that are left. And so if they get a proportion of each, then that third party didn't get any proportion. So there's nothing, no credit to be had.
Okay, I think we're going in the right direction there. Come on, let's kick this around for a minute. What is the goal of comparative fault? Link liability with fault. You've seen that in these cases 100 times by now, right? You've heard me say it 100 times by now. The whole idea of comparative fault is to link liability with fault. Having said that, how would this credit work in a comparative fault world, if at all? Yes, sir.
It reduces the tortfeasor who has fault assigned to him by the amount they settle. It makes sense.
Okay. Yes, ma'am.
It would reduce it by the amount they were only liable for, so the bank would be only responsible for the portion that they're liable for, not for the total.
Okay, so, all right. I mean, let's put all these thoughts together here, and I think when we do that, you see that the bank would be liable only to the extent that the bank is at fault, right? Which is what you said. To take that then a step further, if the bank is liable only to the extent the bank is at fault, is there any need to even things out, as it were, by further reducing that judgment? The answer is no. In fact, a contrary rule would impose liability in a way that is disproportionate to fault. Why should the bank, having been found liable only to the extent that it is at fault, be able to then argue that its judgment should be reduced even more? That would be a windfall for that tortfeasor. So in a comparative fault world, you really shouldn't run into a Rosenbaum kind of situation. Does that make sense? If liability is being linked with fault, there's no need to adjust a judgment one way or the other. And if you do that, now liability is imposed disproportionate to fault. Let that sink in a little bit. Okay. Let's talk a few minutes about a couple other issues that arise when damages are allocated among multiple tortfeasors, namely indemnification and contribution. This can for some reason, people seem to, I don't know, conceptually, for some, this seems to be difficult, the indemnification and contribution. But let me see if I can just cut through some of it and explain this in a way that at least I can understand it. And if I can understand it, I think you can too. I like to think of indemnification. Well, let me back up even one step more and just set the context for indemnification and contribution. These are remedies sought by defendants against other defendants. This is the mop-up, as I mentioned a little while ago. Once we get to the point in a case where we're talking about indemnification and contribution, the plaintiff has been made whole. He's taken that check to the bank. He's done. He's out of the case. He does not care how the defendants are left to divide up the damages among themselves. So that's what I mean when I say indemnification and contribution are remedies asserted by defendants against other defendants. Indemnification is the shifting of the entire loss from one tortfeasor to another. I like to think of indemnification as reimbursement by the tortfeasor who actually committed the tort to the tortfeasor who didn't, but is liable for it anyway. So, to say the same thing a little differently, indemnification places the loss on the party who actually committed the wrong. Even though he didn't pay the damages. Say, for example, well, going back to my Walmart truck driver hypothetical. Let's say Walmart pays the plaintiff that, whatever that judgment was, that $50,000 judgment. At that point, Walmart, we got to leave workers' compensation principles out of this. That will complicate things. Just forget about, if you know anything about workers' compensation, just forget about it for a second. So Walmart, the employer, pays based on what the employee did. Walmart can then turn to the employee, the bad actor, and say, okay, I had to pay the plaintiff because of what you did. Now you have to reimburse me. That is, you have to indemnify me because I'm out because of what you did. That's indemnification. Shifting the entire loss, not part of it, but shifting the entire loss from the tortfeasor who didn't do anything wrong, but who had to pay the judgment, onto the tortfeasor who actually committed the wrongful act. It's the shifting of all of it. All wrapped up in this concept, reimbursement. Contribution is different. Contribution allows a tortfeasor who is jointly and severally liable and who pays more than their share of the damages to assert a claim against other tortfeasors for their share. So contribution, unlike indemnification, apportions the loss among those who are and I almost hesitate to use this word, but are at fault. Fault is such a loaded term in torts, but it works here. Indemnification shifts the loss from somebody who is faultless to somebody who is at fault. Contribution doesn't shift anything, but it allocates the loss among tortfeasors who are at fault. A couple of other points before we look at the two cases that involve these concepts. The first point is that at one time, the common law, and in those jurisdictions that still follow the common law, contribution was not allowed. It's not a remedy. There's no such thing as contribution under the common law rule. But a majority of states have changed the common law by statute, and Tennessee is one of those. And our statute is the Uniform Contribution Among Tortfeasors Act that you read about. The UCATA, Uniform Contribution Among Tortfeasors Act, which does depart from the common law that says a defendant can't seek contribution against other defendants. The other point is comparative fault related. In those states that do not follow comparative fault, and there are some, defendants are required to pay the damages in equal shares. Not to the plaintiff. Remember, the plaintiff is out of the case by now. But defendants are required to pay the damages. They're required to allocate the damages among themselves in equal shares. That's called pro rata contribution. So if there are two defendants, each is responsible to the other for 50%. If there are three, they're responsible to one another for a third. If there's four, they're each responsible for a fourth when it comes to allocating the liability among themselves. Pro rata contribution. In those jurisdictions that do have comparative fault, contribution is imposed based on relative percentages of fault, and that's called comparative contribution. So we've got pro rata contribution. In some states and other states, we have comparative contribution. And that brings us to the first case, Wharton Transport versus Bridges. Mr. Collins, tell us about this one.
First of all, the facts of this case come about in 1972, which was way before a lot of you were born. But from a personal note, it was a very good year. Martin Lawson submitted an application to Wharton Transport to become a truck driver. And on the same day, they sent him to Bridges Clinic for his DOT examination. Dr. Bridges returned a certificate signed with the approval of Dr. Bridges stating that the physical characteristics, including vision, reflexes, and extremities were normal and that he was qualified to drive. 3 days later, he was on his,
Go by himself?
to the,
Not Warren.
Lawson.
Yeah, did the prospective employee go for his physical exam by himself?
I did not note that. I don't know.
We're told he did not.
He did not. Okay.
The Wharton employee went with.
With-
Okay, so he's examined.
He comes back and takes a written test and a driving test, passes those. 3 days later, he's sent out on his first solo trip. And then a couple of days later, when he's on his way back to Memphis, at 4:15 in the morning on May 27th, he collided with a station wagon that was parked 2/3 of the way off the paved emergency lane on the west side of I-40. The road was straight and level. The weather was clear and it was dark with no moon. The car was occupied by Sergeant Paul Raines and his 4 children who had pulled over to sleep. The accident severely injured 3 of the kids, killed 1 child, and caused minor injuries to Sergeant Raines. Lawson, the truck driver, was unhurt. Wharton settled with the Raines family for $426,000. And Wharton's
In exchange for
for a release.
a release.
And then Wharton discovered that Lawson, just 5 years before that, had been deemed 100% disabled, physically disabled, and unemployable in 1967.
But he somehow passed his physical exam.
Right.
Well, how did that happen?
I'm not sure, especially based on the laundry list of ailments that his doctor noted from
Well,
1967.
so what's wrong with this truck driver?
He was 95% blind in one eye, the proverbial blind in one eye, can't see out of the other.
Literally.
Literally. I mean, and then he had
He's all but blind.
severe arthritis.
Let me ask you something there. Did Dr. Bridges acknowledge that this man's vision problems would all by themselves disqualify him from driving a truck?
Yes.
Yes. If that's all he had, was just the problems with his eyesight, he's not qualified to drive. What else, though, is going on with him?
He had a degenerative disc disease in his neck and lower back, arthritis in his left knee, which caused that joint to lock. He had problems with his right leg and ankle with arthritis as well. And he also suffered from chronic fatigue and depression.
Just the kind of person you want driving a tractor trailer.
Right. And Dr. Bridges did not note any of those on the certificate.
Did Dr. Bridges concede that if he missed all of these things that he was negligent?
Yes.
Yes, he did. He acknowledged, if I missed this stuff, I committed malpractice. So you have to read very carefully some of the court's, I don't know, tea leaves here, but in light of Dr. Bridges' concession that if he missed all of these things or any of these things, that amounted to malpractice, what is his defense?
That he owed no duty to a third party.
Okay, that was part of it. His argument, part of it was, the plaintiffs here, the Raines family, they weren't my patients. I owe the duty to my patient. This case is actually the precursor to 2 more recent duty cases that we've looked at in the health care context. Bradshaw versus Daniel, the TIG case, remember that one? And then Pittman versus Upjohn, the micronase case, where the physicians in those two cases made this same argument. And it was rejected in this case and rejected in the two more recent cases. So part of his argument is, I didn't know a duty. The court says, oh, yes, you did. But I don't really think that's his defense on the merits of the case.
I don't know. He would.
Remember, I asked you a little while ago, did he go by himself?
Right. So was the argument that Wharton should have been responsible because they should have caught part of that as well?
Well, I think Dr. Bridges' argument is, I never examined this man. He took his buddy with him, and he knew full well he was not going to pass an exam. And so his friend stepped in for him, and that is who I examined. That's the only way that I would have given this guy a clean bill of health and sent him on his way to drive a truck. But the procedural posture of the case at the time that the Court of Appeals decided it wasn't about the merits. And so very little is said about that piece of this case. But I have no doubt that when it was tried on the merits, if it was tried on the merits, that would have been the defendant's argument. I never examined this guy. They tricked me. He knew going in, he'd flunked the vision test, did nothing else. Wharton that settled with the plaintiffs is looking to Dr. Bridges for indemnification or, in the alternative, contribution.
Right.
Is Wharton entitled, let's take those one at a time, is Wharton entitled to indemnification?
According to what the reasoning of the court was that, or Wharton alleged that its tort liability was purely vicarious and they were an innocent party possessing an implied right of indemnity against the negligent physician.
What do you mean by innocent? When I hear the word innocent, my brain automatically goes to criminal.
That they were not responsible. It was their employee that was responsible for the accident. And the only reason they had that employee on driving is because the doctor certified him to be.
So when would Wharton be able to shift the entire $426,000 to Dr. Bridges? Wharton says, Dr. Bridges, I had to pay the plaintiff because of what you did. Now you have to reimburse me for the whole thing.
When they could prove that he had a duty to.
Well, yes, if he had a duty, but what else? Not just the duty, but he was also negligent, but what else? Go back to your word innocent. Who has to be innocent?
Wharton has to.
Yes. Wharton, the proof has to show that Wharton was not negligent. And if Wharton is not negligent, and Dr. Bridges was, that's a case of indemnification or reimbursement. What about contribution? When would, or how would Wharton be able to seek contribution from Dr. Bridges?
Would it be because Dr. Bridges, the forms that he filled out for the DOT examination stated explicitly what would disqualify a driver?
No. Go back to your word innocent.
Okay.
When can if indemnification, let's say, is not an option, Wharton argues, okay, then I'm entitled to contribution.
Again, because Wharton is innocent on the,
Just the opposite.
okay, so if Wharton wasn't innocent? Is that,
Well, is that a question?
that's,
Somebody help him out. Under what circumstances will Wharton be entitled to contribution? Yeah.
Respond against superior.
No. Well, I mean, in a very general sense, but yeah.
If Wharton was independently negligent. If Wharton was also negligent.
Yes. And Dr. Bridges was negligent. Now you have two negligent parties. Two. And therefore, Dr. Bridges would be responsible for half, 50% of that $426,000 that he would have to pay to Wharton, not the plaintiff. Plaintiff is out of this case. This is the mop up. Plaintiff's been made whole. This is a fight among defendants about, okay, now how do we allocate the damages that were paid to the plaintiff?
so contribution can only be if both
Yes.
both suffered some form of negligence. Okay.
That's the difference between contribution and indemnification. If Wharton is faultless, was not negligent, that would justify shifting the entire loss from Wharton to Dr. Bridges. But if Wharton is likewise at fault or negligent, that means that the court can allocate the damages. And at the time this case was decided, Tennessee was a pro rata state. So two defendants, 50%. Thank you, sir. Let's just go right into the next one. Burboats versus Hardy Rolls Pontiac. Miss Casey, where yeah, there you are. By the way, years ago, the plaintiff in this case, or actually the plaintiff's spouse, was a student, which made discussion of this case pretty interesting. What happens in this one?
On July 5th, 1980, Lee Jackson, a minor, consumed alcoholic beverages at Cactus Jack's restaurant. It was operated by Adenac. After leaving the restaurant, Jackson was involved in a car accident that caused severe and permanent injuries to the passenger, which was Burvoits. And he filed a negligence lawsuit against Jackson and his parents. Safeco Insurance Company as the
Y'all do
Jacksons.
not see me.
It is
I'm
warm.
the only one that's like,
It's hot. No, you're welcome break.
my apologies.
It's okay.
Negligence.
Yes, that was an intentional tort right there. Trespass. I went beyond the scope of the consent given. Probably that camera right there. So if I'm not here next week, it's been great. At least we're not going to be reduced to just a puddle on the floor. Sorry.
It's okay.
Go ahead.
So Safeco, the insurance company, filed a third-party complaint against Adenac, alleging negligence per se for serving alcohol to a minor. In 1983, so 3 years later, Safeco and the Jacksons settled with Bravotes for $1.25 million.
We just give you some indication of just how significant the injuries were here. This case settled for over $1 million. What happens next?
So that released all claims against the defendants. Safeco then pursued a claim against Adenac under the UCATA. And
So what's the problem?
well, the issue is whether Adenac should be tried under the principles of the UCATA or comparative fault. So my understanding is that this case was happening at the same time as McIntyre v. Valentine.
McIntyre had been decided 2 years earlier.
Okay.
So McIntyre was already out. And then this case comes along.
So they amended at some point after McIntyre was decided.
Who amended? What do you mean?
The case against Adenac was amended.
Oh, okay. I'm with you.
So Safeco amended their complaint.
Okay. Yeah, I understand. What is the problem here? Why? What?
The problem was that the UCATA provided contribution among jointly and severally liable tortfeasors based on the pro rata share, and so that was inconsistent with comparative fault principles.
Was it ever? In fact, the court sets out a paragraph from Part 5 of McIntyre that we looked at back when we did McIntyre. It didn't mean a thing to you when we looked at it. But here it is, front and center in this case. And that paragraph says, because a particular defendant will henceforth be liable only for the percentage of a plaintiff's damages occasioned by that defendant's negligence, situations where a defendant is paid more than his share of a judgment will no longer arise, and therefore the Uniform Contribution Among Tortfeasors Act will no longer determine the apportionment of liability. Along comes this case, and the restaurant argues you can't recover contribution because a predicate of contribution is joint and several liability. And the court abolished that in McIntyre. And then in Part 5, even said expressly, the Uniform Contribution Among Tortfeasors Act will no longer control. How does the court, so just to be clear, the argument is contribution was abolished in McIntyre. Contribution requires joint and several liability, and joint and several liability was rendered obsolete. There went contribution. how's the Supreme Court wrestle this down?
Well, I think in this case they were actually seeking indemnification. So,
They thought both.
okay,
But let's stick with contribution.
okay. Um,
The argument is that the court implicitly abolished the remedy of contribution in McIntyre.
it looks like the court says they did not completely abolish the remedy because that remedy was granted to the parties by the legislature.
Well, McIntyre is pretty clear. Quote, the Uniform Contribution Among Tortfeasors Act will no longer determine the apportionment of liability. But you're exactly right. In this case, the court said, of course we couldn't have abolished the remedy of contribution because that remedy has been provided for by the legislature. And we can't just swoop in and abolish what a statute provides for. Absent constitutional problems, this involves none of that. So the court concludes that contribution was not abolished, that it is still a viable remedy. It's just that something has changed. And what is that something? In light of McIntyre and the adoption of comparative fault, what has changed with contribution, according to this case? It's still a remedy, but what has changed?
The pro rata share approach?
Yes. Because now liability is imposed based on relative percentages of fault, right? And if we're going to link liability with fault, contribution needs to do the same. So now when contribution is sought, it's based on relative degrees of fault. The common law was changed from pro rata to comparative contribution. And the court was able to do that without violence to the statute or violating the separation of powers concept. Bottom line in this case for us, and you just put it away, what's the big takeaway from this?
I think I would restate what you just said, that the pro rata share approach is what was abolished,
And in its place,
and in its place was apportionment of
Yep.
fault.
yes, comparative contribution. This case took Tennessee from pro rata contribution to comparative contribution in order to be consistent with McIntyre, the adoption of comparative law. Thank you, ma'am.
Thank you.
The law is always evolving, always evolving. And so it was on this issue too. The court changed the common law in Burwitz, as we just discussed. The legislature eventually caught up and modified, amended the Uniform Contribution Among Tortfeasors Act to specifically provide for comparative contribution. So the change that the legislature made to the statute effectively codified Burgett's. Is contribution still a viable remedy? Everybody say yes.
Yes.
Yes. Comparative fault did not change that as a remedy. It's just that how you apply it was changed. Time is never on our side. I wish Torch just went right on to 10 o'clock. And then we could just keep on going. I mean, I don't need to be anywhere until early tomorrow morning. We just keep right on, just talk about the law. All right, so this is what we'll need to do. Let's just stop here instead of getting into the next step in all of this. So next time we'll start at this point. Mr. Hall, we will do Vols versus Leeds. Probably start right off the bat with that one. And then finish this material, which won't take all that long. And then go into what I think you will enjoy much more, or at least find more interesting than what we've been doing. Animal law. Dogs and cats, here we come. But first we have to get through the rest of this, and that's where we're going to start next time, okay? All right, so make sure I get the roll. I'll see you next week.